We're going to start. Good evening, everybody. Dear friends, dear students, dear all. We're very pleased to welcome you for this first Emmanuel Gaillard Debate. And I would like to thank, on behalf of the Arbitration Academy, our two key speakers, Dr. Yas Banifatemi and Professor George Bermann. We're very pleased and honored to see them, and they were the two ones, of course, to start with this first edition of Emmanuel Gaillard Debate. I would just say a few words and to pay tribute to Emmanuel. That was 2 years ago that we started to think about a debate taking place after the inaugural lecture and Bertolt Goldman lecture. And Emmanuel very nicely started to be one of the first and the first one to debate with Dame Elizabeth Gloucester. For those who were there, that was a very nice experience. And we know that Emmanuel was really at the very beginning, at the creation of the Arbitration Academy. He gave already a lecture. He was always on our side. He was also a very nice sponsor and long-time friend of the Arbitration Academy. And it was, of course, thanks also to the generosity of the institute he created, International Arbitration Institute, and also with the support of his law firms, first Sherman & Sterling and GBS after, that we are here also tonight. And I would like to thank also very much on behalf of the Academy, Yas, for organizing also and sponsoring the whole event. Many thanks, Yas, on behalf of the Academy. Not only we will have a very interesting debate, but we will have also the chance to have a cruise all together, starting around 8. So I will be strict on the questions, not to be sure to miss the boat. Aside from that, that's a very interesting topic that we're going to speak about. And I'm going to give the floor to Karine, not to delay the debate. Many thanks.
Thank you, Daniel, and welcome again, everyone. The topic of the debate is the arbitrator's jurisdiction. Who decides? We're hoping, we're expecting, we're willing a fierce debate between two very strong characters of our international arbitration community. I will give a few words. We usually say they need no introduction, but it's always kind to recall what we owe to Yas Banifatemi and George Bermann and give a little bit of view on their achievements so far until tonight. Yas Banifatemi is the founding partner of Gaillard Banifatemi Shelbaya Disputes, one of the founding partners. And before that, she co-headed the arbitration disputes at Sherman & Sterling with Emmanuel Gaillard. Yas has secured many landmark victories in arbitration. One of them we all know are the 3 awards in the UCOS cases. But not only is she an excellent lawyer, she's also very involved in our arbitration institutions. She was a vice president of the ICC, sat at the LCIA, is an arbitrator in the panel of the ICSID, and also at the SIAC, amongst others. Yas teaches, she also writes, and I have a whole series of citations about how exceptional, brilliant, one of the best technicians, etc. she is. I will simply just get out of the world of the arbitration to say that also Vanity Fair cites her on a regular basis as one of the most influential French people in the world. And we're going to turn to George Bermann, and that's another inspiring actor in the arbitration community. George is a law professor at Columbia Law School. He teaches both European Union law and also international arbitration. He is the co-director of the Center of International Commercial and Investment Arbitration. He also teaches, and we are lucky in Paris, in Sciences Po, where we see him from time to time. George was a lawyer, a brief period of his time. then came back to teaching. He acts very regularly as an expert, as an arbitrator. And I will end with a final word, which is that George was probably one of my, in the best teachers I've ever had. For what it means to me, I hope it will mean to others as well. As Daniel said before we turn to the discussion, the questions will be reserved for the end, and we will just let the debate flow at the beginning.
Thanks, Karine. We are going to start the debate right now, and as Karine just said, the global theme is the arbitrator's jurisdiction. Who decides? That could bring a lot of issues, a lot of questions. And the very first one will be about the following topic. Does arbitration provide for an extraordinary, or on the contrary, an ordinary jurisdiction? And that could rely, of course, on the question of consent to private justice, but that would lead also to the question of jurisdiction and, of course, a policy which could be pro-arbitration or, on the contrary, reserved towards arbitration. So we're going to start, and Yas, if you want to start to launch this debate. Thank you.
Thank you, Daniel. Good evening, everyone. It's lovely to see such a packed room. We were told to have a friendly conversation rather than a fierce debate, and since George and I are friends, I think it makes it much easier. So, to the question of does arbitration provide for an extraordinary or an ordinary jurisdiction, I will start with quoting Article 2 of the New York Convention, which you should be familiar with. The court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, shall, at the request of one of the parties, refer the parties to arbitration, unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. You're familiar with this provision, of course, and you know that the New York Convention now binds 170 states around the world. So the combination of the wide success of the New York Convention and the obligations that it contains, including this obligation that is mandating the courts to refer to arbitration, show how arbitration has become an ordinary means of resolving international disputes. I want to give you a few examples of courts around the world and how they viewed this topic. I'll start with the US Supreme Court, of course, honoring George. The way that the US court have defined this is really to focus on the pro-arbitration policy of the Federal Arbitration Act. So in Marmet Healthcare, 2012, for example, the Federal Arbitration Act reflects, I quote, an emphatic federal policy in favor of arbitral dispute resolution. And you also have the famous AT&T Mobility decision of 2011, where the court said again that the Federal Arbitration Act reflects both, I quote, a liberal federal policy favoring arbitration and the fundamental principle that arbitration is a matter of contracts. I'm sure we'll come back to this since this will be the heart of the discussion later on, but we really see how the US courts look at this. Canada, the Federal Court of Appeal of Canada in 2012, in Canada Moon Shipping, I quote, arbitration has become a favorite method of settling international commercial disputes generally. This led to the adoption of various international instruments, etc., etc. Another example, the Cairo Court of Appeal, in 2011, I quote, resorting to arbitration has become the legal framework that satisfies the wishes of the parties in the field of commerce and reflects their commercial interests. Arbitration is even seen from a practical point of view as one of the foundations or necessities of international commercial dealings and a necessary tool thereof acknowledged by the legal system of the state, every state. Another example from Kenya in 2021. I quote, arbitration as a dispute resolution mechanism is not imposed on parties. They choose it freely. when they do so, they send the message that they do not wish to be subjected to the long, tedious, expensive, and sometimes inconvenient journey that commercial litigation entails. This is what party autonomy, a concept that the courts treat with deference, is all about. And finally, last but not least, the Paris Court of Appeal in Bargue Argot Industries. Arbitration is the usual means of dispute settlement in international commerce. In French, considérant que l'arbitrage étant le mode usuel de règlement des litiges de commerce international. So you see there's a widespread recognition of arbitration as an ordinary means of settling disputes. It's not universal or it's not unanimous, let's put it that way. You have, for example, this decision from Qatar, the Court of Cassation in 2014, where the court said arbitration is an exceptional means to settle disputes as an out-of-court ordinary proceeding with and its accessory guarantees. It's based on the law, which authorizes the parties exceptionally to take their dispute out of court jurisdiction. So you have these, not outliers, but these instances where the court will refer to arbitration as an extraordinary means, but more often than not, you will see the recognition that arbitration today is really the ordinary method of dispute resolution in international arbitration. And since we are honoring Emmanuel tonight, I would like to quote from Emmanuel on this very topic because he actually spoke about this in his keynote speech of 2017 titled Consent, the Essence of an Ordinary Jurisdiction. And I quote, "The degree to which arbitration is considered as an exceptional rather than ordinary jurisdiction will inform how much courts seek to control the arbitration process a priori. Of particular relevance to this discussion is the practice of some courts, when seized of a matter covered by the arbitration agreement, to review the parties' consent to arbitrate in a detailed manner before the arbitrators have had the opportunity to do so. This practice persists even in jurisdictions generally favorable to arbitration. For instance, the US courts uphold a general pro-arbitration policy, but have also adopted the practice of allocating certain jurisdictional gateway issues, we'll talk about this of course, for interlocutory judicial determination before those issues are referred to the arbitrators. One prominent proponent, of course that's George, of this approach paints the illustration of a portal through which a party seeking arbitration must pass before arbitration may commence. The conception that parties who have consented to arbitrate are required to pass through a portal or gate guarded by court judges in order to reap the benefits of their arbitration agreement evidences an unnecessary diffidence towards arbitration. Courts in other jurisdictions have unequivocally affirmed their trust of international arbitration as an ordinary form of adjudication and have rejected these types of measures aimed at controlling a priori the arbitral process. Whether one accepts that arbitration is an ordinary jurisdiction or not, there is doubt that party consent is the predicate of the entire system of international arbitration. Without consent, or even a presumption of consent, an arbitral tribunal can have no jurisdiction. This is true to arbitration based on contracts and arbitration based on investment treaty." End quote. So the question then is how trusting or distrustful of arbitration and the arbitral process one must be. This could be viewed as the plain understanding of a pro-arbitration policy, not blind deference to the arbitral process, but the recognition that as the normal adjudicators of international disputes, arbitrators can be trusted with the ability to assess the existence, validity, and scope of the arbitration agreement, and thus with the neutral and objective determination of their own jurisdiction as any adjudicator would do. So conceiving arbitration as an ordinary jurisdiction informs the interpretation of arbitration agreements and the extent of judicial intervention in the arbitration process, namely to what extent courts will protect the parties' agreement to arbitrate and render it effective. I will stop there because this is just the opening of the concept that we will develop later on.
Yeah. Thank you, Yas. There actually is, interestingly, there's a a high degree of congruence in our views. So we're going to try to explore areas in which there isn't congruence in our views. Speaking of ordinary and extraordinary, I fully agree that arbitration has become an ordinary, if not the ordinary, means of resolving international commercial disputes. On the other hand, and this is a nuance, I think it's fair to say, it is the view in the United States, and it's my view, that despite that, access to a court is the default rule. Access to a court is the default rule. And as you said, arbitration becomes available when the parties consent to it. But in the absence of consent, you're in court if you're going to have an adjudication. So in that single respect, Yas, I would say arbitration is extraordinary, only in the sense that it's not the default venue as a matter of law, and the parties must consent to it. And I know you agree with that proposition. So for me, ordinary has two meanings. Ordinary meaning usual, no question. But ordinary meaning the default, the place you go if you haven't reached an agreement, in my judgment, is necessarily the courts. So in that sense, and it's a very different use of the term, in that sense, I would say arbitration is extraordinary, even though it is far and away the most popular way of resolving our disputes. I don't think at the end of the day there's on that level a great difference of view. I think when we start talking about the trustworthiness that Yas referred to, we'll have some differences of views perhaps. But Yas, I don't think you would disagree, or would you, that access to a court is the default rule as a matter of law? Or would you disagree?
I do not disagree that arbitration is subject to consent, of course. So there has to be consent by the parties to go to arbitration. Now, when we refer to ordinary means of resolving dispute, is really the extent to which arbitration today is chosen widely by parties. In commercial arbitration, and again, we have investment arbitration as well, as the standard normal means. If you go to if you engage into a contract, you will not go to court. You will go to arbitration, international disputes, and so on.
You'll get no disagreement from me on that. It is far and away, I would say, let's call it standard, means of resolving disputes. No question.
Yeah. So I think we agree on that. The question then becomes the trust.
The trustworthiness. And that's really where there's, I think, a great deal of misunderstanding that obtains. I would say that it is, because it is a matter of principle, that one, in the American view, has default access to a court, that a party, if it seriously contests whether it consented to arbitration, that decision, if one wants a court to decide it, should be available for a court to decide it. I don't think that means distrust. And there I think we have an interesting discussion. I don't think we're distrustful any more than a French observer would be. I'm certainly, myself, very trustful of arbitrators. That will come as no surprise. It's not a question of trust, it's a question of ensuring consent. And the fundamental difference is that while we certainly think the tribunal has competence, is perfectly free to determine the bounds of its jurisdiction, if a party wants the jurisdiction of a tribunal to be determined, it should be not by the tribunal, by the body to which it claims it didn't consent in the first place. I don't know if I'm being clear here, but I hope I am. The idea here is that if one did not consent to arbitrate, then why should one's consent to arbitrate be exclusively for a tribunal whose authority is by definition being questioned? I think I'm not so much arguing in favor of that as trying to explain the American thinking on this. But I think that is the American thinking. If my arbitration agreement was a forgery, I'm not prepared to say a tribunal won't do the right thing. But we say, well, if it was a forgery, or allegedly a forgery, then why should the ultimate decision be that of the body that derived its authority from a forgery? And in a way, I think you act on that view because you will fully review jurisdiction after the award is rendered. So it's really a question of timing.
So when you say you refer to the French conception.
Well, I don't know if it's France or Yas, because I know there is some difference.
I don't pretend to represent anyone other than myself. If I go back to your previous point, why choose arbitration? If you choose arbitration, it is to be subjected to that forum. It's not to choose arbitration and then go back to courts. If you're avoiding the courts in the first place and you choose arbitration, there's a reason for that, right? So
yeah, the reason you chose arbitration is to have the merits of your dispute resolved by a tribunal. But did you confer jurisdiction on that tribunal? Did you or didn't you? And we're prepared, and I favor this, it's no secret, right? We're prepared to say that if you insist, you demand a hearing in a court on whether you agree to arbitrate, you're entitled to it. But that's not inconsistent, in my judgment, with having agreed to arbitrate if you did agree to arbitrate. So, yes, you agreed to arbitrate if you agreed to arbitrate.
I see Professor Cohen.
I just want to, I don't want to intervene or to interrupt anything. I think it's very interesting in terms also of the principle of competence, and also the principle of favor arbitrandum, and also it relies on philosophical or historical grounds or cultural grounds, how you see justice, or if this is a delegation of the states, or if it's really a right from the parties. But I think we could move on, and we're going to go maybe a little more in the technicalities now, and Karine is going to explain the...
So, Georges,
I still want to answer.
You said something where actually you said, well, that's what you do in France in the end. So when we review the award and then we look at jurisdictional questions, etc. So could you actually expand on what you've called, I think in one of your articles, the gateway issues, and which is what we call the US approach. And actually, it's not exactly the French approach. The other one, we would call it the transnational approach.
Yeah. I'll be glad to do that, but I have to say that I don't dissociate myself from the word transnational. I think there's nothing antagonistic between my thinking or U.S. court thinking and transnationalism. But the gateway concept is really put this way. There are many reasons to challenge arbitral jurisdiction. There are many reasons. There may be a dozen grounds. But some of those grounds implicate consent. Okay? Was an arbitration agreement formed? If it was formed, was it validly formed? Does it cover the dispute that is at hand? And are you, as a non-signatory, to be treated as having consented to arbitration? Now, those are standard grounds for seeking to defeat an arbitration agreement, and what they have in common in the American view, and in mine, is that they implicate party consent. But there are other reasons to resist arbitration that have nothing to do with party consent, and they're non-gateway issues. Did you waive your right to arbitrate? Now, you agreed to arbitrate. The question is, did you waive your right to arbitrate? Has the statute of limitations run on your claim? Well, you agreed to arbitrate. That's not in doubt. But the timeliness may be in doubt. Did you satisfy a precondition to which you agreed, a precondition to arbitrate? Well, I would say you agreed to arbitrate. The question is whether you satisfied a precondition or not. And has the dispute at hand been previously adjudicated so that the previous adjudication is res judicata? There, too, you agreed to arbitrate. So in the American conception, and I think it's fair to say this, there is a dichotomy between and among the grounds for defeating or seeking to defeat an arbitration agreement, and it's only the grounds that implicate consent as to which you have access to a court if you want. There's no question that arbitrators have jurisdiction to decide all of those questions. Competence positive. No question about that. The question is, if your challenge is that you didn't consent to arbitrate that dispute, those are so richly imbued with the concept of consent, which we both agree is fundamental, that those are the issues where we have a portal. So that's been the Supreme Court's view. It hasn't articulated it quite as clearly as I have, but we know from the case law that that distinction is drawn between choice or consent-based objections and non-consent-based objections. So that's the gateway, non-gateway point. There's, of course, more to be said, as you know, Karine.
Yes, what do you think? Shall we, because consent is so key, shall we, to both of you actually?
Consent is key. I think that's a common denominator to determination of jurisdiction in arbitration. You cannot have arbitration without consent. So the question is not so much the existence of consent. The question is who determines consent and when, yes, as you said. So the question of timing.
Exactly.
Right. So going back to your previous remark, which I think is related to this, when you say a party who alleges forgery and therefore that party wants the court to be deciding that issue, it's a matter of fairness to both parties, because if there's an arbitration agreement, there's a contract. With an arbitration agreement in that contract, both parties have an expectation that that contract will be given effect, including its arbitration agreement. And therefore, the body that has jurisdiction to determine that question will be the tribunal. So assuming that the recalcitrant party who doesn't want to be brought to arbitration says, it's a forgery, I want the court to make that decision, the other party still is relying on the arbitration agreement and on its entitlement to have that decision made by the tribunal. So the issue is that in those instances, it's always the recalcitrant party rushing to the court and trying to create disruptive litigation and saying, I have an entitlement to court. So the question really, to me, comes to, and that's really the rationale of the regime that we have in France and in a great number of countries, and that frankly follows from compétence in both its effects, right? So the issue that I have with what you propose is that there's a fragmentation of jurisdictional matters. So anything that goes to existence, validity, and scope would be the courts, because
not exclusively, only if a party wishes.
Well, one party says, I have an entitlement to court decision on this question, and therefore the other side finds itself in the court litigation despite its will and having to litigate that matter, whereas its consent was to go to arbitration. And for anything else, which is res judicata, question of admissibility, and so on and so forth, it would be the arbitrators. So in fact, you create two regimes, and you allow two regimes where the court would be, in the first instance, having jurisdiction to decide those fundamental matters of existence, validity, and scope of the arbitration agreement, and then whatever is the remainder would be for the tribunal. So that, to me, is not only a question of inefficiency of the process, but also a question of distrust of the tribunal, of the arbitration tribunal, because ultimately, as any adjudicator, arbitrators have the jurisdiction to make that decision and have the authority to make the decision before the court. So we'll come back to that in terms of timing and who decides first and so on. But the difficulty that I have with Gateway is that it creates a regime of fragmentation of the decision-making process for questions of jurisdiction.
Well, I know we have other questions, but let me respond briefly to that one.
You're going to answer this one, of course, but also if you can speak about the review or the determination of jurisdiction, who speaks first, finally, the state court?
Well, let's be clear about this. It isn't binary, and there's a tendency, I don't think you have this, but there's a tendency to think, oh, the gateway issues are for the courts, and the non-gateway issues are for the tribunal, and that's not the case. Tribunals have gateway and non-gateway jurisdiction. I want to be clear about that. So it's the only question is, even though the tribunal has jurisdiction, are you entitled? Now, on your main point, Yas, when you said, in a sense, it's not fair to the other party which consented to arbitration, that it has to go to court. But my answer to that is, well, it may have consented to arbitration, but the recalcitrant party says, I didn't agree to arbitrate. So there isn't consent to arbitration if only one party consented. So I have a problem with saying you must go to arbitration because you consented to arbitrate.
If one party alleges.
It's always an allegation. Right? It's always, and I actually think there's this fear, and you've articulated it, there's this fear in France, and I think it's justified to some extent, that parties who go to court are troublemakers. Parties who go to court are mischievous. Parties who go to court are disruptive. I mean, you more or less said that. They derail the arbitration. Now, I prefer not to think of parties who want to assert their right to go to court. I prefer that they not be thought of as mischievous. Now, I realize that if your only goal in life is that arbitration proceed as efficiently and efficaciously and as quickly, and there are as many arbitrations as possible, that your view would make much more sense. But in the Gateway article, I think I can't put it any better than I am now, we're trading off legitimacy and efficacy. And we in the United States, and I myself personally, do not put the efficacy of arbitration on a pedestal. I'm not prepared to make efficacy trump legitimacy. And it's that thinking, whether you adhere to it or not, it's that thinking that if legitimacy, if consent is an issue, then maybe we can afford to have the arbitration slowed down because legitimacy is that important. I mean, that's the thinking. It's not that we want to allow mischief. It's not that we want disruption. There may be disruptive, no question. And it may delay the arbitration. But it's being delayed, at least allegedly, and I agree with you, it's allegedly, in the interest of legitimacy as we see it. I don't think that implies that I distrust the arbitrators.
It's exactly that what it means.
Not at all. I think it's the forum that you're entitled to go to if you did not agree to arbitrate. And I'm not prepared to say that the courts are being mischievous or parties are being mischievous if they are asserting their right to litigate because they did not agree to arbitrate.
So 2 points on this, if I may. The first is that if you look at it from a very pragmatic point of view, in real life, what parties do in real life, I don't think that the French courts are naive or that the courts elsewhere are naive when they give effect to competence. I think that they simply are given effect to the decision by the parties to go to arbitration and to live by that decision.
If they agreed.
If they agreed.
Yep,
I'm
that's my
coming to that.
point.
I'm
If
coming to that.
they agreed.
I'm coming to that. The first point is there's no question of mischievousness. It's a real life question of disruption, ancillary litigation, and additional cost, additional time, and delays and disruption. This is the reality. This is what you do see in arbitration. This is what I see every day. So going to court for the recalcitrant party to say, no arbitration, I didn't consent, there's forgery, there's corruption, there's this, that, and I don't want the arbitrators to make that decision, I want the courts to make that decision. That in itself is a disruption of the whole arbitration process because that party at the beginning said yes to arbitration in that contract.
Not if it was a forgery.
Well, that whole issue then, I'm coming to my second point, that whole issue has to be determined by the arbitrator. And why is it such a difficulty for the US courts and for you as the proponent of the US approach to accept that legitimacy comes from the arbitrators? And the fact that the arbitrators are going to decide first is not undermining legitimacy of the process. So in other words, the safeguards of the process and its legitimacy is not only the courts, it's also the arbitrators themselves. So we have to trust the arbitrators to have that ability and to make that decision. And that doesn't mean that the court process is completely removed or disappears. It's a question of the courts being able to intervene at 2 stages. They can intervene at the beginning, at the outset, on a prima facie basis. If there's a forgery, if it's completely obvious, manifest that it's a forgery, courts can't say, yes, on a prima facie basis, arbitration doesn't exist. Consent to arbitration doesn't exist. So at the outset, the court can make that determination. But if the court says, prima facie, I look at this and there's no issue prima facie, you have to go, and if you have more issues of jurisdiction to raise, you can raise it with the tribunal, go and talk to the tribunal and come back to me if you have a problem. That is still a legitimate process. And the courts retrieve their full power at the end of the process through setting aside, through enforcement proceedings. So there's nothing wrong with allowing the arbitrators to go all the way, not take them for mineurs sous tutelle. They are actually adults who have the full ability and full authority, full power. They should be left to do their job, and then the courts can review. So I think it's a question of real, it's not only efficacy, it's also legitimacy. And the legitimacy is undermined if the court says, there you go, there's one party that contests the arbitration, I'm going to intervene. So court intervention, and that's the real test of the efficacy and also legitimacy, because you deny the arbitrators the legitimacy of their own.
Well, actually, I'm going to speak heretically. I want to deny the arbitrators jurisdiction if they don't have it. I want to deny them jurisdiction if they didn't earn it and didn't get it.
But how?
How? The institution to which you had a right to go if there was no agreement.
If I may suggest something, I don't think you're going to be in agreement on this subject, but maybe it's also a natural and logical consequence of the fact that arbitration could be seen as ordinary or not so ordinary process of resolving disputes. It's just a suggestion. But maybe, George, you can go back to your explanation with the evolution of the US jurisprudence, which is very interesting for all of us because it's brand new. Yeah. And we'll see that maybe some differences could be apparent, or it's not like necessarily a big difference between different systems right now. But
well, I'll be very happy to do so, even though it pains me to have to report what I'm about to report, because there is convergence happening, but I think it's happening in spite of the principles of American law, whether you like them or don't. So in the landmark decision, which goes by the name of First Options versus Kaplan, the Supreme Court said parties have a right to have their disputes in court, and they have a right to have disputes over whether they agreed to arbitrate decided in a court. That's consistent with what I've been saying. But it added, and this is the interesting part, in the interest of party autonomy, the parties can agree to forfeit. They can agree to abandon that right of access to a court, but only if they do it, quote, unquote, clearly and unmistakably. So what the Supreme Court said in that case was, you have a right, access to a court. If you wish, you can go straight to the arbitrator if you'd like. You have a right of access to a court if you wish on whether you agree to arbitrate. But if in your arbitration agreement, even though you're contesting it, you gave up that right, you forfeited that right, then party autonomy means that you cannot go to the court for that. So what we're seeing in the last 10 years is a very, very rich jurisprudence on what constitutes clear and unmistakable evidence of an intention not to be able to go to court, even though one might want to do so. And as you know from our prior discussions, there are two lines of cases. And the first one is fabulous in terms of our conversation here. The first one is if there's a competence clause in the rules of procedure that you adopted, or if there's a competence provision in the lex arbitri, then you have forfeited your right. In other words, under that view, competence is both positive and negative in the French way of seeing things. That isn't what American law said, but our lower courts are saying effectively, if you agreed to let the arbitrators determine their competence, you deprived courts of their right to determine arbitral jurisdiction. Now, if under that view, a partisan of the French view should be very happy, because in essence, you will have to arbitrate, and you'll have to arbitrate your grounds for seeking to defeat arbitration. You're going to have to arbitrate consent because you agreed to arbitrate consent. So under this case law, which the Supreme Court has not endorsed, nor has it rejected, under this case law, we've come very, 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 very close to the French system. But I would say even worse, because under American law, if you made a delegation, you lose your right to full independent review by a court, not only before the arbitration occurs, but after the award is rendered. And that means at no stage at all do you have, and that's going well beyond France, where, as I understand it, you allow the arbitrations to happen with relative speed and efficacy, but you are prepared to have an award annulled if a court post-award finds that there was no consent to arbitrate. Now, this case law in the US is taking that away. So you do not have access to a court for an independent judgment of consent to arbitrate at any point in time. And I think, tell me if I'm wrong, Yas, but I think that might even trouble the French observer, that neither before the arbitration nor after the arbitration are you entitled to a judicial determination of this. Now, before Yas responds, we have a very recent Second Circuit opinion which said, oh, there's another way in which you can clearly and unmistakably abandon your right of judicial access. The Second Circuit said, oh, if you argue jurisdiction to the arbitrators, even if you're the claimant and you were defending the arbitration agreement, if you addressed jurisdiction to the tribunal, you've given clear and unmistakable evidence that you do not want judicial access. And I hope everybody in the room will think a little bit about what the implications of that are. If you contest arbitrability in the American sense, if you contest agreement to arbitrate to the tribunal, which has competence, agreed? Then you have clearly and unmistakably given up your access to a court at any point in time. So there's a big divide between what our lower courts are saying and what I think is the correct understanding of the Supreme Court. The Supreme Court has not yet agreed to decide this issue, despite my having filed countless amicus briefs to encourage the court to decide this issue. But it has declined to do so. But I'm very interested, Yas, in your reaction to this second species. The second species being you disputed or you sustained jurisdiction before the arbitrators. The courts are off.
The Mongolia case.
The Mongolia case, which you sat on the tribunal.
Apparently, I was on the tribunal, yes.
Yes, Yas sat on the tribunal.
And the courts decided not to annul the decision.
The court decided not to annul your decision. Brava.
Well, I was not chair, but I was indeed
Yeah.
at that arbitration.
But it decided not to annul it because it said it doesn't have authority because you, claimant, Chinese company, you abandon your right to de novo independent judicial review because you defended jurisdiction before the tribunal. That case law does not implicate you, Yas. It implicates the Second Circuit.
So, I will start with the criterion used by the Second Circuit Court that arguing jurisdiction before the tribunal is in effect a clear and unmistakable evidence of consent to arbitration, right?
Of abandonment.
Of abandonment of the...
Of judicial access.
Right, and the delegation. So that, to me, was bound to happen. And I think that's when you start, the starting point being first options, where you have that sort of division between what can be brought before the courts and what remains within the realm of arbitrators. And there's not enough clarity as to what would be the clear and unmistakable evidence. Or, if you take it in another way, anything can be clear and unconvincing evidence to the extent that reference to arbitration rules would be clear and unmistakable evidence, right? So creating a dichotomy only then to have a broad possibility for the parties to take this is clear and unmistakable evidence, it was bound to come at some point, which is that arguing questions of jurisdiction is a clear and unmistakable evidence by the party to consent. I think that it's something that I'm not surprised has come in the US case law. Of course, you will disagree. I'm not an expert of US law as you are, but looking as an observer.
But the American
outside,
international arbitration community as a whole, is horrified by that decision. Horrified. And all it does is demonstrate the Second Circuit's ignorance of arbitration. I don't think it is inevitable.
The assumption is first option, right?
The starting point is first options.
Exactly.
Now, if our courts call things clear and unmistakable, that aren't clear and unmistakable, yes, we have a problem. And we have that problem today. But I don't think it's inevitable. I don't think it should be so hard. I don't think it should be so hard for a court to recognize that that is not clear and unmistakable evidence.
So that's a question of US law. I'm again, as an observer, I'm not surprised that this will have happened at some point. The question is whether first option is the right approach in the first place.
Agreed.
Right? Which I think is not.
I fully understand.
So that's what I'm saying. If the starting point is first option, then you have the possibility that this would come some way. And if the US community is dead against it because they do believe that first option is the right decision. So it's a question of approach, really.
I totally agree with you.
That was my first point. My second point now is that I don't believe it's a French thing against the rest of the world. I think it's a truly transnational view of international arbitration. You have that in Europe, in a number of countries, with nuances here and there. In England, you have a nuance. In Switzerland, you have another nuance. But in Asia, in Latin America, in Europe, you have this recognition that competence has a meaning, and if you give effect to what competence is, you have to go all the way. If you stop short in the middle, you simply are not given an effect. You simply are not only distrustful of the arbitral process, but you are essentially devoiding it of any meaning. Now, to your question, the fact that the court, the Second Circuit, said there will not be review, I agree. To me, and now I'm expressing only my own view, I'm not talking for the French court or anyone else or elsewhere, I think that the integrity of the process and the legitimacy does come with court review.
Yeah.
So, and that is the New York Convention. That is Article 2. And Article 2 does say refer to arbitration unless you find that, right? So there is a place for courts.
Yes.
There is a place for courts prima facie at the beginning, and there's certainly a place for courts at the end. So all that competence does, and the negative effect, and I really, again, this being a debate bearing Emmanuel's name, I want to pay tribute to Emmanuel because he was the one coining the concept of negative effect of competence. What that means is simply that the arbitrators will be the first to determine. They don't have exclusive authority. They are the first to determine for themselves whether or not they have jurisdiction. Just in the same way that any permanent body would make a determination. Competence, if you go to the International Court of Justice, competence, it determines for itself whether or not it has competence. So it's a legal fiction. It's a legal fiction that's accepted in international law. It's accepted in arbitration law. And so it allows for the arbitrators to make that determination first, subject to court review.
Well, we're going to be going in circles. It's evident going to be going in circles because, but I've already said this, so you can cut me off. If you did not agree to arbitrate, then why is an arbitral tribunal deciding whether you agreed to arbitrate? I mean, it's as simple as that. And I don't think it's a lack of trust. I really want to emphasize that, Yas. I don't think it's a matter of we don't trust arbitrators. America is pro-arbitration.
I'm not sure.
No, you're giving pro-arbitration a very narrow meaning. Here's my view. You're not pro-arbitration just because you have as many arbitrations as possible. You're not, I want to repeat that. You're not pro-arbitration just because you have as many arbitrations as you could possibly have, or have them as quickly as you have them. I believe that if you really mean to be pro-arbitration, then you go to the barricades for consent. And that enhances the legitimacy of arbitration. And that is the real pro-arbitration move. So I'm not prepared to see you in France have this wonderful arrangement whereby you have as many arbitrations as you possibly can have. You know, let's not kid ourselves. Paris and France want there to be as many arbitrations and for them to proceed as quickly as possible. And then maybe there'll be an annulment. But that, you have to acknowledge that that is your starting point. You want arbitration to be, how shall I put it? It is the prime value. And even though I challenge consent, you want me to go to the tribunal to which I did not consent. Now, I don't see why that is so. The only serious objection to it, I think, is that it's not efficacious for arbitration. But we don't live for the efficacy of arbitration. Arbitration is not the sole value in the world. Now, I'm an arbitrator. I'm a professor of arbitration. I love arbitration. I am pro-arbitration. But I don't think that having as many arbitrations as you can manage and having them as quickly and as uninterruptedly as possible is necessarily being pro-arbitration.
That, of course, is a caricature. I think that you have to recognize that arbitration is a market. Mm-hmm. So that it's not exclusive to the French or Paris as an arbitration market, or London or Singapore, everywhere, New York for that matter. They want to also have a number of arbitrations. They don't succeed as much as the French and the English and the Singaporean maybe, but it is a market, so you have to recognize that it's a market.
Of course, so I do.
How many arbitrations exist and how fast it goes, that's not the concept of pro-arbitration. Pro-arbitration means that when you create a regime, you trust that regime to be functioning from beginning to end and to be self-sufficient. Yeah. Right? So simply your assumption is very different from my assumption. My assumption is that if you have a process, if you have a regime, if you have arbitration law, and you trust that regime to be fully functioning and performing, you have to trust that system and to allow it to perform. And then if you have, at the end of the process or at the beginning, on prima facie, you have a difficulty, that is also resolved. But that is part of the legitimacy of the process. So that's being pro-arbitration. Pro-arbitration is not necessarily having hundreds of arbitration. It's respecting the process and respecting the players of the process to do what they're called to do. And if you're talking about the legal fiction, going to the International Court of Justice and say, you do not have jurisdiction, it's the court that decides. There is no illogicality in the fact that the court would say, I have jurisdiction, I don't. So why not let the arbitrators
I'll tell you why.
also say, I have jurisdiction, I don't. I assume, and I hope that when you're an arbitrator, when you do not have jurisdiction, you will say, I do not have jurisdiction.
Of course. But don't confuse arbitration with the International Court of Justice. The International Court of Justice does not derive its jurisdiction from the consent of the parties at the time the dispute arose. Parties agreed in advance that they would submit to the International Court of Justice's jurisdiction.
Consent.
But if the predicate is consent,
exactly,
then we have different ways of ensuring consent. And I think you're totally correct. The problem from the French point of view lies in first options. There's no question about it, because first options posited that you have that right. You abandon it only if you do so clearly and unmistakably. And therefore, the genesis of the problem you and I are discussing lies in first options. Totally agree. I happen to support first options. But there's no doubt that first options is the reason for our difference of views, because it's contrary to the French way of thinking.
Transnational.
I don't allow that to define transnational.
Before we turn, you wanted to add a word?
It's okay.
Yes, no? Okay. Before we turn to the questions, Georges, I just wanted to come back on this Second Circuit decision, which somehow is importing competence into the US system. Or
Exclusive.
Right.
Negative competence.
Negative, yeah, the positive and the negative aspect. Because if you count, as Yas mentioned, there are many countries in the world whose lex arbitri recognizes competence. You find it in international institution rules. So there's what should the Supreme Court? You said you filed an amicus brief. You don't really agree. What do you think the Supreme Court then should decide to put things straight?
The Supreme Court has only decided first options. It has never decided a later case on what is clear and unmistakable evidence. Now, the law uses vague terms. No question about it. And what is clear and unmistakable, we can disagree over what is clear and unmistakable. But the fact that a competence, first of all, competence in the US is positive only. So the fact that you have a competence clause in your rules doesn't turn positive competence into negative competence. So we aren't even living by our own definition, which is not the French definition of competence. But what these two lines of cases do is they defeat first options. Now, Yas will be happy for first options to be defeated, but they will defeat first options because they're turning what is supposed to be exceptional, clear and unmistakable, was meant to be exceptional. Now, as a result of these two lines of cases, competence clauses are ubiquitous. They are ubiquitous. What does that mean? That means there is always clear and unmistakable evidence because there is always a competence clause. And the Second Circuit, well, it's absurd. Of course, Competence means that you do argue jurisdiction before the tribunal. Do you do that at the price of losing access to a court? So I believe that the purpose of first options, like it or not, and I understand our difference, but the purpose of first options and the heavy presumption in favor of access to a court if you want it is thoroughly undone by this case law.
If I may add a nuance, Karine, I think that I'm not sure to what extent is a true recognition of negative effect of competence. If you understand it as simply a rule of priority for the tribunal, for the arbitrators, subject to control, right? So the fact that the court said there is no control because once there's delegation, that's the end of the story, we're not going to intervene, that is not really negative effect of competence. Negative effect is simply a timing of arbitrators being entitled and having full authority to decide all matters going to their jurisdiction, not only a fragmented part and having a different regime of what goes to the arbitrators, what goes to the courts. So full authority to decide everything subject to potential review at the end. Well, so that's my nuance. I don't think it's a real recognition of negative.
Well, that's why I agree with you. And I think the Second Circuit opinion is going way overboard. It's negative competence plus you get no judicial review.
Plus waiver of review
yes.
in the countries that
So it's a perversion. I mean, it is a perversion. And the fact is that I'm not the only one who filed an amicus brief. The entire city bar of New York filed an amicus brief saying, Supreme Court, please overrule this decision. There are plenty of amicus briefs, none on the other side. Mongolia had no allies. It had no allies, not a single amicus brief in support of Mongolia. So I think the court has gone way, way overboard and well beyond what you do in France, and I regret it. Well beyond.
In fact, that's true. It's a way to allow also a waiver to launch an action to set aside against the award, at least on the basis of the control of jurisdiction. And you can do it under different legal provision, and especially for France. But you need an express consent to do that. And there will be, as Yas was saying, always a control on the determination of jurisdiction by the court at the end of the day, but not like priorly before the arbitral tribunal will state on that.
Well,
it's transforming the negative effect into from a priority to an exclusivity.
Yes, I totally agree with you, and I've never disagreed with you on that. I mean, the timing is different. You will get your day in court on jurisdictional issues after the arbitration has occurred and after an award has been rendered. And what divides us is obviously whether you should have a right to pre-arbitration. And there's no there's no reconciling our views because
assumptions totally different. Yes.
Assumptions are totally different. And I want you to know that Yas and I are fast friends. And Emmanuel and I were fast friends, as you know. And Emmanuel and I had debates like this, I think, countless times. And neither of us budged. And I don't think Yas and I are going to budge. But I think it's a terrific discussion, if I can say so, because we both are acting out of the utmost sincerity. I have no doubt about the sincerity of your views, and I hope you don't doubt the sincerity of my views. And I think it's extremely interesting how these rather distinctive views can be held so equally sincerely by two different people.
Thank you, George. If I may just have a small interruption in our very nice debate. I have the gentleman who organizes the cruise, and he told me earlier that if we do not make it at 8:30, we will miss the time and we will have to come back 1 hour later. So I don't know where you are with your questions. Monsieur, c'est vous qui nous dites.
Well, that's a very good remark. So maybe 2 quick questions, if we may, for like 3 minutes or something like that, 3-4 minutes, and then we can go on discussing on the boat. And thanks again to the generosity of GPS Disputes. We are going to be able to go on the boat for 1 hour and a half or a little bit more. So it will be very pleasant. So if you want to ask questions, go please quickly. Go ahead. Sorry.
Well, it's a question, it's a comment. Coming from Italy, you know, France is great in wine and cheeses, but you will be surprised to hear that there are other countries in Europe, continental Europe, where there is very good wine and very good cheese, and we never call it transnational to make it more appealing. I think if you look to the applicable law, because something which was completely missing in the debate was a reference to the lex arbitri. The lex arbitri may be different. The lex arbitri is chosen by the parties, and parties should make an educated choice, because the American and the French position are 2 positions. There are many different ways of addressing the same problem. For instance, the German Constitutional Court said, or perhaps the Supreme Court, they said that squared arbitration agreements, those that according to first option would confer the power, are null and void. So you cannot even expressly write in the arbitration agreement that disputes on the validity of the arbitration agreement can go into arbitration. This is Germany. In Italy, you have a completely different situation. You have parallel routes, and the question is timing. If you decide first before the judge, that decision is going to be res judicata for the arbitral tribunal and vice versa. So what I'm suggesting is, please do not discount the importance of what the parties want. And the parties, when they choose the seat of arbitration, they are buying 2 things with that. They are buying the lex arbitri, and they are buying the jurisdiction of the relevant courts. And if they choose Paris, they buy that concept, because the transnational conception of arbitration is a French concept which applies when you have French jurisdiction. If they come to Italy, they buy whatever we have in terms of competence, which is both positive and negative, but you can, how can I say, modulate that in many different ways. Let's not forget that the prima facie approach is not expressly written in Article 2. Article 2 of the New York Convention says you refer to arbitration unless the arbitration agreement is null, incapable of being performed, and so on and so forth. There is no prima facie soft analysis there. You may read that, of course. You may not read that, because when the New York Convention was entered into, states which normally exercise jurisdiction is one of the sovereign functions of states, and I am in some way with the Americans, the natural place where you go for settling disputes are courts. It's not strange to think these are the normal place. I know there are theories. The Luxembourg professor, what is his name, the one teaching the Max Planck in Luxembourg, wrote that the natural jurisdiction is arbitration. But this goes against the tradition of many countries. In many countries, the exercise of jurisdiction is a function of the sovereign state. States with the New York Convention were expressly agreeing to reduce that power unless the arbitration agreement is null and void. And who decides? It's a vicious circle, because if there is forgery, and forgery could also be forgery on the agreement to delegate to the arbitral tribunal the power, then that's not consent. Sorry, perhaps it was more a comment than a question.
Maybe one last question. In fact, thanks for your remark. If there is one question, if there is a question.
It's not so much a question, it's more an observation to George, because we've debated a lot on the travaux préparatoires of the New York Convention together and the pro-enforcement bias. And I think we had the discussions today about what is the interpretation of pro-enforcement. And you distinguish maybe the US and what you call the French one. But the fact of the spirit, and you know this, of the New York Convention was the recognition of arbitral awards to the greatest extent possible. At the time, the idea was circulation of arbitral awards, which needed to be reinforced. And I think Professor Fouchard, for the 40th anniversary, reminded that, and I think everyone agreed to that. Now, this means putting arbitration on the pedestal. This means not having more arbitration for the practitioners to have arbitration, but ensuring that arbitrators have the possibilities of rendering an award without obstacles, which is in a very restrictive way as Article 2 was interpreted. And I know you've just discussed about how do you read Article 2, but you read Article 2 with a pro-enforcement bias. That is the way it was intended. So I understand from you that the US courts, which is I'm not surprised of, but maybe have a bit departed from that spirit. In the same way that for awards that have been set aside, when they look at the award, the decision annulling the award, rather than the award itself, which is the key of the New York Convention, which is the center of the circuit. You allow an award to circulate. You focus on the award, you allow arbitrators to. So I'm just a bit troubled by the fact that I'm not putting on a pedestal. You think that the French are putting this on a pedestal. This is actually the spirit of the New York Convention.
I actually disagree. I think you're failing to distinguish between the arbitration agreement and the award. The United States is as pro-arbitration vis-a-vis the award as any other jurisdiction in the world. We do not read the New York Convention defenses broadly. Just read your US cases. Those defenses are to be narrowly construed. But whether you agreed to arbitrate in the first place, Article 2 said a court is not to compel arbitration if it finds that the arbitration agreement is null, void, inoperative, or incapable of being performed. Now, I would like that to be taken seriously. Is that a problem?
That is taken seriously by the courts elsewhere by having a prima facie review.
But you're entitled to that.
Yes, and both interpretations are possible under the New York Convention. But Benjamin says, and I agree, there is a pro-arbitration bias that you can interpret as meaning prima facie. But I think that
not when it
we're
comes
coming
to
really
consent.
to the end of the
Not when it comes to consent. There should be no pro-arbitration bias when it comes to consent.
Right.
And we
We're
will
not gonna
never
agree, right?
Yeah.
We will never
We
agree on
agree
it.
to
I don't think we put the same meaning under the term consent, and maybe that's why also it's a difficult question. It's really time to go now. I would really like to thank very much our two key speakers. That was, in fact, a real debate with characters, with strong ideas, and I'm sure that Emmanuel would like it. And he was a man of great trust and also ideas and theories and practices. So we're going to join now and meet on the boat. Thank you.